Imagine you have gone through the challenging process of bankruptcy, received your discharge, and are finally looking forward to a fresh start. But then an old creditor contacts you, attempting to collect on a debt. What happens next, and what are your rights in this situation? After your bankruptcy case concludes and the court issues a discharge order, creditors are legally prohibited from attempting to collect on any debts that were included in and discharged by your bankruptcy. This means that for most types of unsecured debt, like credit card balances or medical bills, collection efforts must cease immediately. This protection stems from what is called the bankruptcy discharge injunction, which is a permanent court order. Once issued, this injunction legally prevents creditors from taking any action to collect a discharged debt. This includes making phone calls, sending letters, filing lawsuits, or initiating wage garnishments. The purpose of this powerful legal tool is to ensure you receive the financial fresh start that bankruptcy is designed to provide, free from the burden of past obligations. If a creditor contacts you about a discharged debt, the first step is to calmly inform them that the debt was discharged in your bankruptcy. It is helpful to have a copy of your discharge order and your bankruptcy case number readily available to provide to them. You should ask them to stop all collection activities. If they persist, you should document these communications, including dates, times, and names of individuals you spoke with, then contact your bankruptcy attorney immediately to report the violation. There are certain types of debts that are generally not dischargeable, such as most student loans, recent taxes, or child support obligations, so it is important to know which debts were actually discharged in your case. An important nuance to understand is that the discharge injunction also applies to debts that were owed jointly with another person. While your obligation is discharged, the cosigner may still be responsible for the debt. Furthermore, if you signed a reaffirmation agreement for a secured debt, like a car loan, you voluntarily agreed to continue paying it, and collection efforts on that specific debt would be permitted. However, for all other discharged debts, any attempt by a creditor to collect is a direct violation of a federal court order and can carry serious consequences for them, including potential sanctions for contempt of court. Understanding these post-bankruptcy collection rules empowers you to protect the financial fresh start you have earned. By knowing your rights and how to respond to inappropriate collection attempts, you can ensure that your bankruptcy truly provides the relief and peace of mind it was intended to deliver, allowing you to move forward confidently on your path to financial recovery.